By now, you know with crystal clarity that the Biden administration and all of the associated Democrats it works with across the country are abusing their powers in the government in order to try and destroy Biden's top political opponent, Donald Trump, and of course, by extension, the will of the people who would vote for him in the first place. And yesterday, there was a bit of a breath of fresh air, a small one, as 4 federal judges on a D.C. appellate court just issued, I think, a really big statement and a smackdown on the effort to trample Donald Trump's rights. For more on this, I want to bring in Julie Kelly, who follows all of it very closely. She's the author of the Declassified by Julie Kelly Substack and the author of January 6th, How Democrats Use the Capitol Protest to Launch a War on Terror Against the Political Right. Julie, good to have you back with us. Thank you.
Hey, Vince. Thanks for having me on, as always.
Of course. If you could, just give us a breakdown of what happened yesterday in this appeals court.
So this was pretty stunning. And in fact, legal observers said it was highly unusual for these 4 Republican judges on the appellate court for the District of Columbia to write this 12-page statement related to the handling, really secret and unlawful handling of obtaining Donald Trump's Twitter data. And it's sort of complicated, Vince. I just posted an article on my Substack, Declassified, with Julie Kelly, that kind of walks through what happened. But what these 4 judges said, and it was authored by Naomi Rao, who is a Trump appointee on the circuit court in Washington, said that this was unprecedented, that this was an end around of executive privilege protections, that the judge in the case on the district court, Beryl Howell, who was the chief judge, and the 3 Democrat judges on the appellate panel who upheld what Judge Howell did, that they should have presumed that these communications were privileged, and they should have given Donald Trump the opportunity to assert executive privilege. Instead, what slimy, dirty Jack Smith did is seek not just a search warrant on the Twitter files, on Donald Trump's Twitter files, but asked and received a non-disclosure order to prevent Twitter from telling Donald Trump about this search warrant for 6 months.
What rationale
preventing him?
I'm sorry, I did not mean to interrupt you, but what rationale could you possibly offer for why the subject of the search warrant would not be allowed to know?
Oh, no, I'm so glad you interrupted me with that. Because both Jack Smith and Beryl Howell, who has been the chief judge, Donald Trump's chief antagonist, by the way, on the most powerful federal court in the country, aside from the Supreme Court, what they both argued is that if Trump found out about the search warrant, he could possibly flee the country. He would cause violence in the streets. He would intimidate witnesses. So this was the application that Jack Smith gave Beryl Howell, and that is the justification and rationale she used in signing off on this non-disclosure order. And that is what Twitter tried to appeal. They wanted, under their First Amendment rights, to fight the non-disclosure order, saying that they had a right to tell their user, Donald Trump, about this. And that's what both Judge Howell and Jack Smith and then the 3-judge panel prevented them from doing. And this was the appeal that was eventually upheld.
Was this the Elon Musk era of Twitter throughout?
So very interesting. Jack Smith, because he's a dirtbag, took advantage of the transition period. So this was January of 2023 as Elon Musk was buying Twitter. And get this, Vince, this is how either ham-handed or dirty they are. They sent this unprecedented search warrant. Nothing like this has ever been done before, as these 4 appellate judges said in this letter. They sent the search warrant to a non-working website portal on Twitter's internet page, where it sat for days with no attorney seeing it. And Twitter's attorneys didn't even know about it until Jack Smith's prosecutors called, finally reached them, and said, oh, by the way, you have the search warrant pending, and by the way, you have 2 days to comply. And that was just part of this drama here. So they set an untenable deadline, didn't handle it the right way, probably intentionally, forced them to produce these records. And I mean, this is a massive trove. This isn't just Trump. This is people, millions of accounts who interacted with Trump's account, accounts that he liked or followed, or other users who liked or followed or blocked or unblocked his account. I mean, this violated the privacy rights of millions of Americans. But Judge Howell, these three Democrats on the appellate court, and certainly Jack Smith didn't care.
So,
but these four judges who did write this, Vince, to your point, it was really a breath of fresh air to finally call them out on violating the Constitution, on violating congressional balance of powers requirements, and case law that demands a former president is entitled to assert executive privilege in any circumstance when anyone is seeking his record.
Right. They should presume right away that anything that's not already public is entitled to executive privilege protections because, you know, the whole idea is that we afford a degree of secrecy to the president's deliberations in order to allow him to have the most space possible to make wise decisions. And that is not what they did here. The court just acted as if everybody was entitled to this information except for Trump himself. And it's interesting that you point out that they used some sort of random comment form to serve the subpoena to Twitter, which is insane to me. And of course, they knew what they were doing. They didn't really want to talk to a human. They wanted to, get it in front of it so they can make the case in front of the court and demand these documents and say that Twitter was out of compliance if they failed to give it to them.
And furthermore, then Jack Smith asked Judge Howell to hold Twitter in contempt of court for not meeting this deadline that they messed up in the first place. So she fined them $350,000 for allegedly failing to comply and missing the deadline for 2 days. Never mind that Jack Smith messed it up in the first place.
Yes, that's right. And this is, of course, they're imposing a fine on another political opponent of Joe Biden, which is Elon Musk, $350,000. So the crazy thing to me, one of the many crazy things here, Julie Kelly, is the feds have no problem getting a hold of Twitter when they want to censor the American people. They've got contacts for that. They literally have conversations about what content to censor. But the second they want to send a subpoena over, they use an online comment form. Is that what happened?
Yeah, where's Elvis Chan when we need him on the San Francisco FBI field office? You know, he's got all the Twitter people on hot dial. And this was before Elon Musk really took over.
Right.
But Beryl Howell, she really needs to be removed from the bench. She is a danger. She is a cancer to this country. The things that she has done, not just to go after Trump, his associates, Republican members of Congress. She also forced Scott Perry to turn over his files, his data off of his cell phone to the government, saying that there was evidence of a crime on there related to January 6th. I mean, this is how dangerous this woman is. So to hear her colleagues in the same courthouse upend her in a pretty stark way. I mean, they did not mince words about what she did here, the unprecedented nature, and the danger for the future, which she wrote. Naomi Rao said, this is not for an incumbent president. Then now these new rules apply to a sitting president. So you could have a special counsel ask a third party, a cell phone provider, social media company, we want all of the president's records. And by the way, don't disclose that to him. And right now you have the case law precedent to justify that.
It's completely out of control. So where does this go from here? These four judges were in the minority, right, yesterday?
They were. So what happened after the three-judge panel, then the next step is to ask what's called an en banc full review, the entire court, 11 or 12 judges, to look at what the three-judge panel did. Well, the entire court denied it. The problem is that Trump did not get involved. He did not assert executive privilege protections. It was too late anyway, because Vince, Twitter was forced to turn over these records in March of 2023, and they already signed off on the non-disclosure, and Twitter really didn't have standing to assert executive privilege for Donald Trump. So unfortunately, the issue by and large is moot, but I'm assuming that Twitter will still seek cert, a petition before the Supreme Court to review now what the lower court, the circuit court, did, and use this 12-page statement from Republicans as cannon fodder to demonstrate how unprecedented, how wrong, how unlawful their acts were.
How filthy this whole thing is. Trump couldn't claim an executive privilege protection because he wasn't even aware that his data was being sought.
And what the judges pointed out is that Jack Smith could have gone to the National Archives. They also have a copy of all of Trump's data, Twitter data, which right there demonstrates that those were official presidential records. He didn't go to the National Archives because it would have triggered an automatic notice to Donald Trump that the government is seeking your records. So Jack Smith, as again these judges pointed out, did this end around. So Donald Trump specifically would not be notified by the National Archives that Jack Smith was looking for his Twitter data.
So the American people elected Donald Trump to be president of the United States, and along with that comes the power and privileges and benefits of being president of the United States. One of those is the notification you just described. Jack Smith, by trying to circumvent that, was quite clearly trying to undermine the will of the American people, wasn't he?
He absolutely was, and that's what the judges pointed out. And that's why they consistently said this is unprecedented. It is unlawful. They didn't say the word sneaky, but they said you obscured the normal process. And then went back to the judges who ultimately are responsible. And what they all wrote about their colleagues, again, is that any presidential material should be presumed presidential material and subject to an assertion of executive privilege. They were all in cahoots, all Democrats, Jack Smith, 4 Democrat judges, 3 Dems on the panel. And keep in mind, this is important, the judge who authored the 3-panel ruling upholding Judge Howell was Florence Pant, the idiot who last week in the oral arguments on the immunity issue brought up the SEAL Team 6 assassination hypothetical. These are the people making the serious decisions in our country, not just for now, but permanently for the future. And these are the reckless partisans who have that power in their hands, and this is how they use it.
It's just disgraceful. I want to ask you about one other Trump legal proceeding today. There's this civil trial going on in Manhattan with E. Jean Carroll. Have you been following the details here today, Julie?
Just a little bit, yes.
It's just wild. That whole case. So people are reminded, E. Jean Carroll's a columnist. She accused Trump of rape. A jury found that they couldn't find any evidence that Trump had raped her. There was no liability for Trump on that. The media has misreported the jury's findings ever since on that subject. And now there's a defamation case going on because Trump insists that he's innocent. He didn't even know her, didn't rape her or anything like that. E. Jean Carroll has sued him again for defamation for basically accusing her of being a liar. Now it plays out in the court. Today, the judge, who is grumpy that Trump is even there, is upset that Trump has been kind of basically mouthing the words or saying loud enough that the jury could hear it, that this is a witch hunt, this is a con job, and has threatened to kick Trump out of the trial. Trump responded, "I would love it," he said. And the judge said, "I understand you're probably very eager for me to do that because you just can't control yourself." So Donald Trump practically daring this judge to boot him from the trial today. Trump's in the fight, and he's going to hearings he doesn't even need to be at, Julie Kelly.
I think the American people are waking up to, just like every other institution in our country, we have a serious crisis in our judiciary. These judges are not responsible. They don't even hide their partisanship. They are mini tyrants from the bench. And of course, we've had this problem for a long time. But now it's completely out of control. And you and I have talked about this, about the judges just overseeing the January 6th prosecution, the same issue. But without enough oversight from the higher courts, including the Supreme Court, or congressional oversight, we are going to continue this descent into where these really, in many cases, stupid judges are making such important decisions. And today, I think it's Judge Kaplan is his name.
Yeah.
It's just the latest representation of that.
Yeah. And they're handling a case that's being funded by a Democrat mega donor. This lawsuit is being funded by Reid Hoffman, the co-founder of LinkedIn, which is, if you're looking for, the connective tissue here, it's all Democrats looking to destroy Donald Trump and anybody who would dare vote for him.
That's right. And by extension now, we see it playing out in D.C. and other places, his supporters, his aides, family members, and his voters.
Yep.
There's no end to how they will abuse their power to destroy the right.
Which is why they shouldn't have that power. Julie Kelly, thank you very much. Always appreciate your reporting and your insight. Good to talk to you today.